Hello, everyone, and welcome to today's Law Path webinar. My name is Ryan Tan, and today we're going to be covering NDIS businesses. So how you can run an NDIS business the right way, and we'll be giving a foolproof legal action plan as well. So just while everyone is joining the webinar today, I'm going to launch a poll. If you could just fill this in, it gives us a bit of information on your business and how we can make these webinars more customizable for your business. And we'd love to know, are you a NDIS provider yet? Let us know yes or no so we can make the content relevant throughout the webinar. But while we just launched this poll, there's a few people coming in as well. Again, feel free to comment any questions you might have in our Q&A box. We also have a chat as well. So if you have any questions or comments throughout the webinar, then you can pin them there as well. Now, Damon will be joining us shortly. So if you have any questions within the scope of an NDIS-based business, then again, prepare them for Damon. You might be a registered or an unregistered provider, or you could just be looking to start doing an NDIS business, but you're not sure where to begin. And if so, then this is a fantastic resource for you to attend today. So I'll just wait another minute or two while everyone joins the webinar, and then we'll go straight into it. Okay, fantastic. So just on today's agenda as an overview, we're going to be going through a bit about LawPath, who we are and what we do, and then we'll be going straight into the webinar with Damon. So we'll be doing an overview of NDIS businesses, launching an NDIS-based business, some common mistakes that are made along the way, and then also the legal documents that are required, including a suite of documents we do have on our library in the LawPath platform. And then we'll close it off with some question and answers from Damon, and then our legal health check as well. So again, if you do have any questions, you can put them in the chat or the Q&A box throughout the webinar. So a bit about LawPath. We provide smart, simple legal for small businesses, and we do this through our legal document library, which we have over 372 documents and growing each week. As you can see, we've assisted over 300,000 businesses, just like yours. We've saved them over $100 million in legal fees. And along the way, we've collected over 10,000 five-star reviews on Trustpilot and Google. So again, we're just getting started on our journey. We also help businesses manage their compliance and connect with lawyers on demand in a single platform. So getting legal advice as well. So I'm going to introduce you to Damon. For those who have been on our webinars recently, you'll be familiar with Damon and his presentations. He's got over 14 years of experience. He's got experience in an array of legal areas, and he's a 5-star rated lawyer as well. He does help a lot of our clients on NDIS. So without further ado, I'll pass you over to Damon to kick off today's presentation. Thanks, Damon.
Thanks, Ryan. How are we doing, everybody? All right. So today we're talking about NDIS businesses. I guess the main question is whether you are already an NDIS provider or whether you're looking to become one. So if you can answer or you can put that into the chat, that'd be great so I can know how to structure this presentation. But at the end of the day, a lot of it comes down to giving case examples, different situations, and hopefully there's a lot of questions that I can answer. And if you have any issues with running your business or hypothetical situations that you've come across, it'd be great to let me know those and we can work through on how to resolve them. And we'll focus on that in the last part of the presentation. So high level, NDIS is a National Disability Insurance Scheme. There's lots of funding for it. It's been an excellent scheme that's been getting rave reviews. There's obviously been some rot within it as well, but that comes with many different schemes that are out there. But what you hear generally about NDIS is it's just a great scheme. It gives people the choice and the freedom to choose who's going to provide the services, and that's what it's all about. And so what we're going to look at is if they do get that choice, then that also means that you're dealing with either a self-managed participant or someone that has a professional behind them. And oftentimes the issues arise from the self-managed ones. And so we'll deal with some of the issues that you might have in dealing with people who have the plan and self-managed. On top of that, we'll also look at some of the main issues that you have, such as termination. Oftentimes our clients are terminated and they're left in the lurch with a bunch of staff ready to go into work the next day and no one to actually be providing services to. So we'll look at some of the key ways to remedy that moving forward. Now, if we look at the different characteristics of it, it doesn't really matter what kind of business you are. There are large companies, charities, not-for-profit, sole traders. One of the things that you want to look at is your corporate structure. And if you've been running an NDIS business now for a little bit, it might be worthwhile having a look and seeing whether it's time to restructure your business. And the reason for that is it comes down to an exit event oftentimes. A lot of times when you're providing an NDIS business, you can be acquired by a larger business and you can be brought in-house later on. And so you want to have the proper structure to be able to bring in that opportunity for future investment, for growth, and possibly for an acquisition. And one of the things that you want to be looking at is converting from a sole trader, into a company. And there's various different benefits to that, but one of the main benefits is switching from a sole trader to a company is it gives you the ability to bring in investment. A lot of times with an NDIS business, you actually need some funding or you need some money in the bank to get yourself running because you have new equipment you need to buy, you need to bring on staff, you got to pay those staff and get paid afterwards. And so if you need to bring in funding, the best way to do that is to have a company. And also if you do have a company, then the question is there a way to minimize your tax, or is there a way to benefit to the maximum extent when there's an exit event? And a lot of times people will create a discretionary trust to be the shareholder of their business. And the reason for that is if you get bought out, you will have a large capital gains tax issue. And if you have a discretionary trust, it might assist you in minimizing that capital gains tax at the time of an exit. So have a look at your current existing structure. I've done previous videos about corporate structuring, and we can send you some links on that as well. But first things first is if you're a sole trader, you've been running for a while, consider switching to a company because it will give you that benefit to be able to bring in investment, hire more staff, bring in more senior executives, create an employee share option plan for those loyal employees that you want to keep, and minimizing your tax in the event that there's an exit event in the future. Now, the steps involved in launching your NDIS business. Just going to pull that up again. So to register, you're going to need to start your business as mentioned, and you're going to need to contact the NDIS Commission to determine whether you're able to become an NDIS provider. And that comes down to mostly the application and the nature of the services that you're offering. For instance, I believe a law firm itself can become an NDIS provider. And if you're already a service provider and you're looking to become an NDIS provider, then there's not as much loopholes or there's not as much requirements to become an NDIS provider because you're already regulated in your own industry. So if you're offering driving lessons, for instance, there are driving lessons companies out there that have become an NDIS provider. There's accountants, lawyers, and so on who become an NDIS provider. And then obviously you have your physiotherapists and other different regulated industries that become an NDIS provider and certified so that they can then go become registered and get paid by the NDIS scheme. Now, when we have a look at whether you need to be verified or certified, that depends again on the nature of the business that you're doing. And we'll talk about the different audits that you need to undertake to become a registered NDIS provider. There are a lot of different issues that most of our clients have. So please make sure you put into your Q&A any kind of questions you have. A lot of them comes down to outsourcing, issues with the actual participant or the participant representatives, termination of the agreement, things like that. So ask the questions so that everybody can get involved, and then we can go through all those at the end. So when you look at getting into the NDIS business, there's a lot of different businesses that provide the same or similar service. And so one of the things you want to figure out is, how are you going to differentiate yourself? How are you going to market yourself? How are you going to build that brand so that you are the preferred provider? And so it's always important when you're getting into this is to do a business plan. Every business should have a business plan. Every business should identify their key competitors and have a look at what the brand is that they're going to create and how to make it a memorable brand. Now, when we talk about brands, a lot of people go and they create their business as, acute care or something that's very generic. Now, if you create a business called acute care, for instance, the reality is that it's probably not going to be able to be registered for a trademark. And the reason is you can't register a generic name and protect your brand, because if you were to get acute care, that means that you are limiting anybody else in the industry of providing medical or professional services from using the word acute care. Now, a lot of the businesses, that's exactly what they do. They take care of someone with acute situation. So when you choose your brand, make sure it's quite unique. Make sure you Google around. Make sure that no one else uses the same brand. And because the last thing you want to do is grow your company, create your brand, pay a lot of money in Google AdWords, pay money in Facebook advertising, and then find out that you're now getting a cease and desist letter from someone who already is trading under that brand. Or you go to try to register a trademark and you find out you can't because it's too generic. So one of the things that LawPath offers, for instance, is a trademark search. And so if you are just about to start and you don't have a brand yet, and you're looking at different names, you can do a trademark search. You can go to IP Australia as well, and you can look up to see whether anyone else has a similar or same name as what you're trying to trade under. Now, completing a self-assessment, this is basically the first step. Now, if you've already become an NDIS provider, you already know all this information, but in essence, you go to the NDIS website, you start the application, you do the self-assessment, you look to see whether you comply with the NDIS practice standards, and that will then look into what you're going to need to do, what kind of audit you need to become registered. The application opens, you can save it, you have 60 days to complete. So if you have any problems with it, you can always go and get some specialist advice as you're going through those questions if you don't have anything. So for instance, you might need a risk management plan, but as you're going through the self-assessment, you haven't completed it yet, you can save it, go get that document, re-upload it, and then keep on going. Now, there are a difference between becoming, getting a verification or getting a certification. So as I was mentioning before, as a lawyer, I don't need to get certified because I'm already certified by the Law Society. So instead I go and do the verification. And what that means is that the requirements for me to become an NDIS provider are much lower because I've already gone through the high requirements of becoming a law firm, which means therefore I just need to make sure that I've dealt with certain practice standards that our firm might not have, like a complaint management process or a risk management process or things that are specific to the NDIS industry. And so in those circumstances, if you're already a professional provider, you're more likely going to be going down the self-verification process. Now, if you're not already regulated, that's where you're going to be going down the certification audit avenue. And the process for that is getting all the documents sorted in terms of what's required for the NDIS practice standards, but then they also have special modules for the different industry or the different kind of services that you're going to be offering. And then you have to go and get an independent auditor to come through and make sure that you've complied with all the requirements. So Again, going back to the verification audit, this is generally for the professional businesses, and then you got to add in your incident management processes, your complaint management, your risk management, things like that. And then the certification becomes a lot more complex, and it can be fairly costly because you got to hire that third-party auditor to help you with the certification. And then the process is, if you've already done it, you know the process already. If you haven't, the NDIS website is full of information. It's very informative. It goes step by step, and it takes you through the entire process. So if you are looking to become an NDIS provider, just go to their website and you can just go through that whole application process, and it will direct you on exactly what you need to do as you go through it. And if you become successful, then you become a registered NDIS provider. If you're not, there might be a few things that you need to fix, but normally if they refuse it, it could be because of, they might say that you're not a fit and proper person. So for instance, in the past, someone who was going to be the director has had a company in the past that went into liquidation. So the commission might find that that director is not a fit and proper person, and therefore they've made the decision not to give you or register you as an NDIS provider. In those circumstances, you can then appeal. And when you go to appeal, you go to the AAT, and that's where you're appealing a government organization's decision. Normally, it's not an area of law, not an area of fact. And normally the NDIS, they are purely discretionary. So they get to choose who becomes the registered provider. And so when you look at what grounds do you have to appeal, it's going to be that they misinterpreted the evidence, or they didn't take into consideration certain things that were put forward to them, or they misapplied the law. So they might have said, well, you've become, you're not a fit and proper person because you were a director of a liquidated company. But it might be that you actually weren't a director of a liquidated company. You might have removed yourself as a director 3 months before that, and they just saw an ASIC extract that showed you as a director previously. That would be grounds for an appeal because they misapplied the facts and then applied that law to those misapplied facts. So the general documents, what LawPath offers, and the general documents that you're going to need in the core module, as opposed to the specific module for your industry, is your services agreement and those policies I've already mentioned. Now, when we look at certain other things that you need to comply with that are not even part of the NDIS generally, you have to look at the Australian consumer law. So if you're providing a service, you have to provide certain guarantees. And this is what comes really important when you look at your terms and conditions that you're getting the participants or the participant representatives to sign. And that is that your services must be of a standard of care. So there must be due diligence. It must be from a reasonable standard of care. It must be performed within a reasonable period of time. It must be fit for the purpose for which it says it's going to be served, and so on. And you can Google Australian consumer law services, and they will show you and lay out all the different services that you're guaranteeing when you're providing those services. One thing is to make sure is that when you actually have your services agreement, you can't contract out of the Australian consumer law. So the way you actually, if you have terms and conditions that just say we're not liable for anything, that clause isn't enforceable. And that clause is going to be struck out from your terms because it doesn't say we're not liable for anything except for those that are automatically implied by the Australian consumer law. So there's a lot of different clauses that you need to be careful of in your services agreement that you need to make sure that they comply with the Australian consumer law. Otherwise, those clauses will be struck out and unenforceable, and you can't rely upon them at all. So have a look at your terms. Make sure if you do have a disclaimer or a limited liability clause, make sure you have a mention of Australian consumer law. And if you don't, you're going to have to either get a lawyer or have a look at the LawPath services agreement and take a clause from there and apply it into your own services agreement. Now, what do we include in a services agreement? A lot of people have taken agreements from past employers or where they've worked previously or stuck together a lot of different contracts. And a lot of the times there's information in there that's not relevant to them, or it's missing a lot of things. So the most essential clauses I'll just run over right now is number one, you really want to make the participant's representative accountable to you. And the reason is that they're the ones that are responsible for making sure you get paid. So I'll go through some examples, but in the past, we've had situations where a coordinator has approved or has provided our client the plan. They've then gone, our client's then gone and done the services. And then after they've done the services, they put their invoices in and there's no money actually in the plan. Now, how are you actually going to get paid? The participant doesn't have any money. The coordinator has promised to you, or should have promised to you, that there are funds in that plan to pay your invoices. Now, if the participant can't pay you, then the only one that can, and the NDIS refuses to pay you, the only one that can would be the NDIS representative. And the only way that you can make that representative liable to pay you for what the NDIS doesn't pay out is if you, one, make them a party to the agreement, or two, get some kind of representation from them. So you can send them an email and say, please confirm the following. You confirm the plan hasn't changed. You can confirm it is current. You confirm there's sufficient funding for us. You confirm that you'll be processing our payments within X amount of days. And then if they then agree to all those, and then you go and provide the services and you find out that at the time they made those representations, they weren't true, then you can sue the coordinator for the money that you're out of pocket for based on misleading and deceptive conduct. That is, you've asked them these questions, they've confirmed these questions to be true. As a result of relying upon their representations, you then provided the services, you've then suffered damage because you haven't been paid. You can now sue the coordinator for misleading and deceptive conduct because they made the representation that you relied upon and you've suffered damage as a result. So one way to do it is getting any kind of statement from them by email, but the better way is getting someone to be an actual party to the contract that you sign off in terms of your services agreement. And normally that's the participant's representative. Other situations that you really want to make sure you have in your services agreement is a debt recovery clause, so that if you aren't paid for whatever reason, then you can claim interest on it and your legal costs for recovering the fees that the NDIS aren't able to cover. You also want to have a look at the termination clause. We've had situations were participants' representatives terminated a contract on our client with no notice, and our client was left with about 10 staff who were rostered for the next 2 weeks, and now they have no work at all for them. But because they're employees of our client's business, our client still has to pay the employee wages, but they're not getting any payment at all because there's been a termination of the services agreement. So you need to make sure you have a clause that deals with situations where there has to be notice if there's going to be a termination of the agreement. And that notice needs to be at least probably 2 weeks, because if you have staff that are rostered, or if you have staff that are, whether they're casual or part-time permanent employees, at the end of the day, if you don't give your staff notice, then you're going to have to pay them. So that means that you need to make sure that your services agreement has a proper termination clause, and there is a requirement for notice to be given. Another situation is a lot of times people have their service agreement that deals with the commencement date and the completion date. Well, the commencement date and the completion date normally goes along with the plan, and it normally comes to an end when the plan ends. But what happens if your client terminates early? Well, what happens if you want to terminate? Do you have any clause to deal with your ability to terminate your services? And do you have a clause to deal with if they terminate early? Also, do you have a clause that if the plan is renewed, what happens between the end of one plan and the start of another? And one of the things you want to have a look at is changing your terms so that it doesn't just end when the plan ends, but you have an alternative. It comes to an end once the plan comes to an end, or when someone gives 2 weeks notice, or otherwise by written agreement, or something along those lines, or automatic renewal clauses where if the plan's renewed, it's automatically renewed, things like that, so that you always have an agreement, even during that time when the plan's being renewed and you have some uncertainties. You want to make sure that your agreement continues to flow and you still have the protections within that agreement while you're trying to get the new plan approved, for instance. Another clause is putting a positive obligation on the representatives. So even if the participants' representatives do not agree to be liable for the fees if the NDIS does not pay, you want to have a positive obligation on them for complying with at least something like a code of conduct that you might want to introduce. So we've had a situation where a participant kept on finding lighters and kept on lighting things on fire. And even though our clients kept on trying to stop them from lighting things on fire, and taking every morning that participant would show up with a lighter in their pocket. And so one of the things is if you have a code of conduct and you make the representative responsible, that the representative is responsible for either maintaining the security, maintaining the health and safety, the welfare, looking after that participant while you're giving the care in certain circumstances, being observant, being putting the OH&S requirement onto them as well as onto you, so that if there was ever an incident, then you can actually pass some of the responsibility onto the representative who is supposed to be monitoring the participant while you are providing your services. And then also a lot of times we get situations with behavior issues where it's the representative that treats your employees poorly. They might be swearing at your staff. They might be not cooperating with your staff. They might not be assisting your staff, whatever it might be. So again, you want to put a positive obligation into your NDIS services agreement that says that the representative will cooperate, act reasonably, act in good faith, comply with your directions, give you instructions and directions when reasonably necessary within a reasonable period of time, comply with the OH&S requirements, observe all OH&S requirements, and have a code of conduct. And you can put into the agreement that the representative agrees that they will comply with the code of conduct, and then put in your termination clause that says if they breach that code of conduct, then in that circumstance, it entitles you to terminate the agreement as well. So those are just some of the things that we regularly deal with when we're looking at the services agreement. Everybody has a different service. Everybody's business is completely different. And oftentimes you need to tailor your services agreement to what you're actually doing. LawPath has an initial template for you to start working off of, but there's always work that you need to do. And one of the things I always say is it's oftentimes when you start a business, you can use a template. It's great. It's great to get going, but then you're going to identify your pain points. And those pain points are certain situations that keep on popping up. And you might not know why it pops up, or you might just find there's a common pattern that always is causing a pain to your business. It's normally at that time you want to step back, look at your terms, see how can I fix that issue. And oftentimes it's hiring a lawyer and drafting up clauses or policies that deal with how to resolve that issue so you don't have it in the future. So you can start with a template, but highly recommend you always revisit your template regularly to make sure your pain points are dealt with. The next one is privacy policy. I think I might have missed one there. Oh yeah, so we also have, so when you apply for your NDIS, you need to have different, you need an incident policy. You also need a complaints policy. LawPath has templates for that. Again, templates aren't always great for your business. So a complaint policy might say that if someone raises a complaint, they're to escalate it to the managing director, and then after it goes to the managing director, they're to report it to the NDIS. That's not necessarily the great complaints policy for you, because you don't want it to go straight to the NDIS and a complaint be made against you right away. So, you know, oftentimes you want to elaborate on that process. So if there's a complaint, they're send it to this email. That email is addressed to the general manager. That general manager will then contact the person that made the complaint. They'll then do an investigation. And if you're going to do an internal investigation about a complaint, and it might be in relation to one of your staff, it means that you need also coinciding another policy that deals with how you discipline your staff. So just because you have a complaints policy for how your clients can deal with you, you need a policy to deal with how you deal with complaints amongst your staff and your colleagues, so that you're not going to get an unfair dismissal in the event that you get a complaint from a staff or from a participant's representative. You then go and investigate it. You find that your support worker was responsible for that complaint, and then you terminate them, and then you have an unfair dismissal. But if you had a complaint policy or grievance policy within your company, then you can follow that policy, and then at the end of that, decide to terminate the employee, and it's less likely they'll have a positive outcome in an unfair dismissal case. Same thing with privacy policies. So LawPath has a privacy policy, but one of the things that it says is that if you're providing a service, then you might provide the personal information to another service provider, and you'll be sharing personal information as part of your services. So oftentimes when you receive personal information, you're not allowed to disclose that to anyone. But there's certain exemptions for medical purposes and medical emergencies, and there's other exemptions when you have implied consent or consent from the actual participant. And in the NDIS privacy policy that LawPath has, it says that you as a service provider are allowed to share that information with third parties. Without that, you might not be allowed to, and you might be breaching the Privacy Act, and you could potentially be sued for sharing personal information or even medical information that you're not allowed to do. So have a look at your privacy policy, have a look at LawPath's privacy policy, and make sure that there's a section in there that entitles you to share that personal information with third-party providers. So you might be a support worker, you need to pass on that information to a nurse from another provider, you want to be able to pass that information over, you need the consent from your participant to do so, and you need a privacy policy to deal with it, or a specific clause within your services agreement. Incident management policy, another one that's required to be an NDIS provider. If you're just starting out, all these policies aren't going to, you would have just ticked a box. You would have grabbed these policies, you would have showed that you had them, you're now a provider, fantastic, not worry about it. But when an incident actually arises and you look at your policy, you might have some concerns with what it actually says. It might escalate it way too fast. It might result in external reporting before you've actually been able to deal with it. And if you breach your policy, you're now breaching your NDIS procedures and your NDIS standards. So if you've been running your business for a while, I highly recommend looking at your policies that you have and making sure they're actually fit for your business currently today, and not just a tick of the box cookie cutter document that doesn't necessarily apply to your business. Another thing that we get is a cancellation policy. This is similar to what we have for a termination, but it might be that you're rostered to attend tomorrow and someone tells you at 9 a.m. the next morning that they're off and you're not required to provide the services. However, you've already rostered your team to show up there. You normally would want to have a cancellation policy. Industry standard is they have to give 48 hours notice or 24 hours notice. No fee applies. If they give less than 24 hours notice, sometimes 50% fee applies. If they give less than 4 hours notice, 100% of the fee applies. Now, in these situations, NDIS might not cover you. And so the reason for that, to have this cancellation policy, is for you to be able to then seek reimbursement from the person that's responsible for not giving you the appropriate notice, which is normally the representative of the coordinator. So have a look if you have a cancellation policy, have a look at your NDIS services agreement, make sure you have a clause that deals with cancellation and notice of that cancellation. Now, a couple examples, I've already raised some of them for instance, or I've already raised them previously as I was speaking, but one of them is non-payment. We get this quite often. And if, company A, they provide the service, they issue the invoice week on, week off, all the time, they're issuing the invoices, then all of a sudden they don't get one paid. And the question is, well, why didn't you get one paid? Who hasn't, have they simply not processed the payment? So that's another thing. We get coordinators who get the invoice and are too busy to actually upload your invoice and get you paid. So you need to make sure that if you look at the remedies and make sure you get paid, make the representative, make the person who's managing the plan responsible to upload your invoice within a certain amount of time and seek the payment within a certain period of time, and be able to charge that interest if they don't pay you on time, and be able to suspend your services if you're not paid as well. And consider getting those representatives to give that warranty or to sign the contract and become responsible for the obligations under your services agreement. The other one that we get all the time is actual workers soliciting away the participants. Now, the NDIS is all about freedom of choice and people being able to choose where they go and where they get their services. But just because it's freedom of choice doesn't mean that a support worker can go, or an employee of yours can go and steal all your clients. That's completely different to freedom of choice. And so oftentimes we have a clause which is called a non-solicitation that you enter into with your contractors and your employees. Now, that non-solicitation clause will normally say you must not solicit away or entice away or perform any services to any of our participants or customers, our employees, or our suppliers, or take them away and reduce the work that you currently get from them for competitive business. And if they do, then you can go and get an injunction against them. Now that means that you can go and run up to the Supreme Court in your state and get a court order that they're prohibited from servicing those people. Now, the reality is that the minute you mention Supreme Court, it's about a $3,000 filing fee. You got to get a solicitor and barrister, and it's going to cost you a minimum of 25 grand generally. And so no one actually enforces a non-solicitation clause. So what we normally draft now is called a business protection clause. It's a non-solicitation clause with this injunctive relief, but it has another clause on top of that, which is liquidated damages. And the liquidated damages is saying, but if you do breach this clause and you do take away the participant, then you're going to buy that participant off of us by paying us liquidated damages, our pre-estimated loss of revenue as a result of your breach of this clause, which might be 20% of the annualized revenue that we would have earned from that participant, but for your breach of this clause. Now, that kind of clause that you draft, it can be seen as what's called a penalty clause. And a penalty clause in Australia is unenforceable. And so what it actually needs to be, it needs to be a clause that's really, really well drafted that talks about what your legitimate interest is. You've spent a lot of time hiring these people. You spent a lot of time sourcing your clients. You spent a lot of money on marketing and growing your business. And these costs that you have incurred, you need to make back by earning these clients and keeping them around for a while. So if your staff steals one of your clients from you, then you haven't necessarily earned the cost that it was to acquire that participant or whoever it might be. And that's why it's a legitimate interest that you have to protect that client from going off to somebody else. And that's why you need to charge this amount, and the amount must be your expected revenue that you would have got, but for what happened, and 20% is normally your margin or your profit of what you would have earned, but for that action that your staff made. So consider putting in this business protection clause into your agreement on top of the non-solicitation clause when you have your employees and your staff dealing directly with your participants and the representatives. I mentioned before the bad behavior, such as lighting things on fire. We also have situations where people are, the representatives might be sitting in the house, they might be just observing, and they might be directing people what to do. They might be bossing people around. They might be super lazy, not doing anything. This goes back to consider having a code of conduct, consider having the representative of the participant to comply with that code of conduct. And if they don't comply, it gives you an out to be able to terminate the agreement. A lot of our clients don't actually have clauses that enable them to terminate the agreement if they're not getting on with the participant or the representative. So have a look at your services agreement. Make sure you have a clause that enables you to terminate. Now, I've been talking for a long time, so I'm going to now refer over to Ryan, and then we'll get into Q&A.
Thank you for that, Damon. Very comprehensive review and presentation. So I just wanted to step in here and share how LawPath can help. Firstly, our contract management system, we have over 372 documents. We've just updated our suite of NDIS documentation on the platform as well. So we have 5 different documents that Damon covered there available for use immediately. We do have personalized workflows as well. So on other topics, if you're looking to register a trademark, maybe you're looking to collect a debt or hire an employee or even a contractor for your NDIS business, then the workflows walk you through the process end to end and link you directly to the documents. And then lastly, booking in legal consultations. So even with the contracts that we have on the platform and the workflows, you may wish to get the NDIS documents reviewed by a lawyer such as Damon. And in doing so, you can stay fully compliant and have the peace of mind that you've done everything correctly. So they're the 3 different services that we offer. In terms of contract management, we also have other documents relating to your business. So aside from NDIS, you might be looking for employment agreements, an employee handbook, trust creation documents. If you're looking at business structure or intellectual property documents, there's bound to be at least 5 or 10 that you can find value in away from NDIS documents. Now, in terms of our plans, we do have 3 main plans on offer. Towards the left, we have our Essentials plan, which is the 372 documents, which is unlimited access to all of them. You can also use e-signature for your own documents and our documents. You can download our documents in PDF and Word file. And lastly, you can add up to 3 team members. So if you have other people within the business that you'd like to issue out these contracts, like an administrative person, then they can be doing that on your behalf. We've then got our legal advice plan in the middle here. So that one offers you, again, unlimited 30-minute calls each month with our lawyers on new topics. So it's a great plan to be able to seek advice on a range of different legal documents and what you're looking to do within the business. Again, you can review all 5 of those documents with our lawyers to ensure that you're compliant, as well as discussing topics through our accelerator program, such as business structure, intellectual property, and if you're going on to raise capital or investment, the whole process can be outlined for you as well. We do cover supplier and commercial agreements, as well as privacy and insurance policies as well. And then towards the right here on our legal advice and accounting plan, it includes the same as legal advice and essentials, but it does include unlimited 30-minute calls with our accountants as well. So if you do need high-level chartered accounting advice around business structure or paying yourself as a director, this is a fantastic plan to get that covered. We do have an accelerator program dedicated to this accounting plan, which covers things like group structuring and asset protection, so you can get more value at a high level. And just one thing to note is that our lawyers and our accountants, they do speak to each other, so they converse on your business, and that is very rare to have. One other thing on this plan as well is the ASIC and ATO agent service. So if you do require company changes throughout the year, our company's team can act as your registered agent with ASIC and make those changes on your behalf. Because again, this is something that we normally charge over $200 per company charge, or we have a plan around $500 that does this. So this is included in that plan. Now, today's exclusive webinar offer for your NDIS-based business, we're offering 20% off our legal advice plan. So it's $100 a month with monthly billing with an annual commitment. So if you'd like to take advantage of this offer we've got going on, comment yes into the chat below, and one of our team will be in touch this afternoon to take up that offer. Now, if you're an existing client with us, potentially on Essentials or even just a paper document, and you'd like to upgrade your plan, please comment in the chat as well. And one of our team will give you a call on discussing the credits available in your account and how you can take advantage of the unlimited legal advice as well through this plan. If you're interested in a trial plan, especially with accounting, we do have some options as well that we can discuss with you. So I'll just pass it over to Damon for some last Q&A as well. Please comment if you have any questions.
If we have any. We have any?
I don't think so.
No. All right. All good. Thank you very much for joining, and that'll be a wrap. Thanks.
Thank you. Just lastly, I'll pop up a feedback poll as well. So again, thanks to everyone who filled out the first poll that we had. We had a mix of NDIS providers and ones that are not registered. So it's good that we can customize it and that the webinar was quite valuable to you all. But I've just launched a feedback poll. If you could just fill this in within the next minute or two. And again, we will customize these webinars. Now the recording for this one will be published on YouTube. So just check our YouTube channel, LawPath YouTube, into Google within the next 24 to 48 hours, and you will see the recording here as well. Perfect. Well, thank you everyone for your time today. And if there's any last questions, then we'll take them now.